was collected.
Okay. What additional video did you collect?
A cell phone video from Mr. Phillips was collected.
Okay. And do you know who or how that video was collected?
Yes, Agent Schultz made contact with Mr. Phillips September 29th of 2025, and that video was provided to him. Subsequently, in preparation for the proceedings today, myself and Agent Davis met with Mr. Phillips on April 6th, and he completed an 1102 and went through the same process as Ms. Wright. The only difference being on this occasion that because he is a minor, his mother witnessed it and also signed the statement.
Okay. So you personally reviewed Mr. Phillips's video with Mr. Phillips?
Correct.
Okay. And you had him prepare a written statement?
Yes, correct.
Okay. Again, on this written statement, are there two different authors?
Yes, I believe in this instance it was myself that wrote the file name on the form.
Okay. And so you wrote, what part of the statement did you write?
Just the name of the file that we were asking Mr. Phillips to verify.
Okay. I'm going to have exhibited on your screen what's been marked States Exhibit 7.1. And this should just be for Agent Hall.
That's on my screen.
Is it on your screen? Do you recognize what that is?
I do, yes.
What is that?
The State Bureau of Investigation 1102 form completed by Mr. Phillips.
Okay. And did you gather that from Mr. Phillips?
I did, yes.
And again, does this statement include the advisory that is going to be used in lieu of his testimony at prelim?
It does.
And does it also include a warning that if he makes a, the author makes a false statement that it could be punishable by being charged with a Class A misdemeanor?
It does, yes.
Okay. Anything about this exhibit look different than the day you collected it?
No.
Okay. Judge, the state would seek to admit Exhibit 7.1.
Ms. Nestor?
Thank you, Your Honor. We would object to the admission on the grounds that this video does in fact show a close-up view of the shooting of Mr. Kirk and grievous injuries in very stark relief. And because of that, we are particularly concerned about our constitutional claims we have made and our standing objection in terms of our ability to get a fair trial if this is published. And I think, again, we have the same issue with the court, being in a position where you're having to make a reliability determination without the opportunity for this individual to be cross-examined. Also, I do think the fact this is a minor that completed this form does make it protected. He's also potentially a victim under the same theory that has been stated for Ms. Wright, and under the UCJA acts for the same reason, the UCJA rules for the same reason, these should be protected private court records, and private means it shouldn't be played to court and it shouldn't be played to the public through the media. So we would object to its admission, we would object to its publication, and we would object to its filming. Thank you.
Any final response?
Judge, let me address, well, there's two things here, right? Let me address first the 1102 statement. Judge, I believe again that this statement was gathered in compliance with Rule 1102B8. Just to check. And the agent has explained that although Mr. Phillips is a minor, his mother was present. And that explains, I believe he said, the second signature on the form. With regards to publishing it, the 1102 statement, that is, Judge, we believe again, the presumption is this is a public record and that it should be not only admitted but published here in court and also published so that the media can record it. With regards to, well, do you want to address the 1102 and then I'll move on to the video?
All right, so we're staying focused on the 1102. Any final response, Ms. Nestor?
No, Your Honor.
All right, thank you. As it relates to the 1102 statement and to the state representative who is displaying it, could you scroll down? I can only see the top half of this. All right. And just go to the very bottom so I can look at the totality of it. This is 7.1. All right, based off what's before me on the State's Exhibit 7.1, I find that it is admissible under Rule 1102 and to the Utah Constitution, Article 1, Section 12, to that paragraph I have referred to previously, and so it is admitted into evidence. And Mr. Sturgill, remind me, were you requesting for it to be displayed? I'm, again, focusing on 7.1.
Right.
In
On
court.
7.1, Judge, with regards to the video, we believe it's admissible. It's been authenticated properly.
Hold on. I'm not talking about the video. I'm talking about
Right.
7.1,
Oh.
publishing it in the courtroom versus publishing it on to be captured by the media.
Because we think that the presumption is it is a court record. We believe that in its redacted form. We believe it should be published in all three areas.
All right, Ms. Nestor, any final thoughts? No, Your Honor. All right. We're going to go ahead and grant the publishing of Plaintiff's Exhibit 7.1 in court and that the media may capture that. Let's go ahead and do so.
Scroll up. Slowly scroll down.
All right. You may proceed.
Did you admit Exhibit 7.1?
It is admitted into evidence and it was
All
published.
right. Have you personally watched Mr. Phillips's video?
I have, yes.
Okay. And what does it depict?
It's a graphic video. Mr. Phillips was positioned towards the front of the crowd, and it does depict the moment that Mr. Kirk is shot.
Okay. And independent of the 1102 statement prepared by Mr. Phillips, you watching that video, do you recognize at least the location of this video?
I do. It's consistent with the event that Mr. Kirk was presenting at UVU on September 10th, 2025.
Okay. Judge, at this point, the state would move to introduce or would move to admit what's been marked State's Exhibit number 7. We would simply ask that it be admitted. We would ask, however, that it not be published beyond that.
Ms. Nestor.
Due to the graphic nature and the sensitive nature of the video.
All right.
So as to the admission, the same issues that we raised as to the 1102, we would raise as to the difficulty of authenticating when the individual is not here present, and all the same concerns that we raised about the 1102 itself, Your Honor.
Thank you. All right. Considering the,
I'm sorry, may I add one more? I apologize.
You may.
And also under Rule 403, we think it's more prejudicial than probative, and we would raise it for that reason as well.
any final response, Mr. Sturgill?
No, Your Honor.
All right. And this is Exhibit 7, is that
7.
correct?
Correct. Exhibit 7, Judge.
All right. I will admit Exhibit 7 into evidence based off the foundation that's laid. The 1102 is tied directly to this, and so for admission purposes, it is admitted. I am not going to authorize publication in the courtroom or obviously through media, but I will have it played on my screen. And so I view it, and I just want to make sure, and please, counsel, given the graphic nature of it, please guard your screens because I believe we all should be viewing this. This is evidence, and I want to make sure that you all are seeing what I see to ensure that that is accurate and it's a fair representation of the exhibit that you are familiar with. So whatever you need to do, I'll give you a moment, and if you could just give me a thumbs up if you're ready to proceed. Again, I want to act in a way that is dignified in respecting the rights of all persons. And for those reasons, I just want to make sure we are safeguarding to ensure this is not captured. All right. To defense, ready to proceed?
Yes, Your Honor.
All right. To the state?
Yes, sir.
All right. Go ahead and let's play Exhibit 7. Is there sound?
There is, Judge.
All right, let's make sure that, thank you.
Gender and marriage.